Hello, everyone. I am watching people slowly trickle in now that, oh, I see how it works. Watching people slowly trickle in as we turn the webinar on. So I'll give a minute for everyone to get settled. Thanks for joining us. This is very exciting. Austin is on the line. He's been helping us put this all together with at Kantor Kantor, and I just want to first thank Austin for all of his hard work, especially figuring out Zoom. I don't know if you all have mastered it so far, but it can be a little complicated sometimes. I'm very excited with for the group that we have with us today. We have Dr. Christopher Snell, who I've worked with closely for several years now, most of my career, helping claimants with long-term, with ME/CFS and other fatigue-related disability insurance claims. My practice has focused on that for a while. But Dr. Snell runs or supervises the lab at the Workwell Foundation with the 2-day Cardiopulmonary Exercise Test, which I'm sure we'll explain as well. Dr. Snell's full bio is in the information that we sent you already, and along that lines, we'll be sending you a follow-up email with lots of information in it, which will also include our bios in case you need a refresher. So all the information can be found in one easy place for you there. Also with us is my colleague Moselle Leland. Moselle is from the Leland law firm. Her and her firm handle exclusively Social Security disability, or other Social Security claims as well?
Well, Social Security disability, which includes supplemental security income for disabled individuals, railroad retirement, which is very similar as well.
Right, got it. And so, Moselle and I were actually introduced by the Workwell Foundation because we were both pursuing a very difficult case for a very deserving person, and I couldn't find anybody to take her Social Security case, even though I knew how deserving she was. And I was pointed in Moselle's direction, and she was able to get this person Social Security benefits, which just about everybody involved had said was a Hail Mary of Hail Marys. She had pretty much counted it out, and so it was a good first impression Moselle made on me. And so if you I don't really know any Social Security lawyers out there who are fighting the way she is for people with ME/CFS and other fatigue illnesses. Also with us is Dr. Teresa Dow. Dr. Dow has spent a lot of time on research for ME/CFS. She's a practitioner. I've worked with her a bit, and I can vouch that she's also one of the fiercest treating physicians out there as far as identifying flaws with insurance company logic and really going to bat for her clients, which is great on a regular basis, but it's really phenomenal when you have someone who is one of the premier researchers and experts in the arena. Again, some of the documentation we'll be providing you, she's listed on all the good stuff. So again, I'm really excited to have everyone here. I'm Andrew Kantor from Kantor Kantor. My practice focuses on all kinds of insurance denials, but primarily disability insurance. And a large portion of that is ERISA disability insurance, which you obtain through your employer, which, as I may explain, depending on the questions, can be a lot more difficult than getting benefits from insurance you buy on your own. I've also spent a lot of my career fighting specifically for people with ME/CFS and other fatigue-related illnesses, because when I started my career, I didn't think there was really a lot out there to help people like that. And there was this huge population of people who, were deserving of assistance that were just not getting it. And so I take a lot of pride in the work I've done in that arena, and I think we're making a lot of progress, believe it or not. And still a lot of progress to be made, especially in this universe, but one step at a time. So what we're going to do is just go through questions. We've got several questions sent to us before the meeting, which we will just kind of start to run through. If anybody has questions during, as we're talking, please just send them to me in this little handy question and answer box down here. And a few other things I'm supposed to mention. We are going to be recording the session and make it available on our websites, and we can send a link directly to you. But because of that, we are not going to be, and other reasons, not going to be identifying any personal information about anybody. We're going to answer the questions to make it, so you should be able to identify they're answering your question, but we're not going to reveal anything personal about anyone. In fact, and if we slip up, we will edit the video afterwards to omit anything like that. If you're not sure if we were answering your question or you want clarification or we never got to your question, just email us at benefitschat@kantorlaw.net and we will get back to you as soon as we can. Let me just make sure I got everything. Oh, one other thing is that, we have, as I've been rambling for 5 minutes now, we are lots of people have signed up today, and I'm very grateful for that, but we want to make sure we get through as many questions as possible. I'm just going to be moving somewhat swiftly, and if I kind of cut you off, I do apologize, but again, just email us afterwards, and I'll make sure your question gets answered in full. So let's get to it. So this is a question for the doctors. I'm sure what everyone is curious about right off the bat. What connection is there between COVID-19 and long-term impacts on one's ability to work?
My expectation is that we will see in some people that an activation of symptoms very similar to ME/CFS. That there is research done on the prior SARS epidemic, a very, very similar virus, and that they did found that there was a number of people didn't recover completely from the illness. So I expect as a post-viral sequence, we're going to see disability related to COVID infections. How that's going to play out, I don't have the crystal ball that's going to give me that answer. If I'm going to be on the optimistic side, I'm going to say that, well, we have an illness here now that everybody is familiar with. Nobody's going to be disputing that it's real. But I also expect that nobody's going to want to start paying out for long-term disability independent of everything else. So a long answer that didn't really answer the question, but I'm apprehensive, but hopeful that we can actually learn something. So one specific thing is that we'll have a lot of fresh infections, so we'll be able to watch the progression of whatever follows from the beginning, rather than with ME/CFS or fibromyalgia, where it can take 5-10 years before people even get a diagnosis. And by then, you don't even know what the original illness looked like.
So what you're saying, Dr. Snell, is this could end up having some net positives for the community?
I think every cloud has a silver lining, and I'm hoping that that's the silver lining here, that there's going to be enough research invested in COVID that we're going to learn something from it that will benefit all the people with post-viral illnesses pre-COVID.
Dr. Dow?
Yeah, I totally agree. So COVID is a coronavirus and SARS was a coronavirus. And so they both go up into the nervous system or the brain. So we're going to expect to see a lot of the same symptoms that you see in ME/CFS. And we'll be starting to see that, the definition for ME/CFS is 6 months of fatigue. So I would say in the next few months, that's when we're really going to start to see people are going to start reporting that they're not getting well, and we'll make more of that connection.
One interesting thing from my perspective is that there's enough research using cardiopulmonary exercise testing with SARS that there's actually a precedent there. So we're not going to be confronted with the idea that, oh, well, you can't use CPET to document disability with ME/CFS because it's never been done before. Well, things have to start somewhere, but there is a history of CPET documenting disability post-SARS patients.
Great, thank you both. So a related question, can you file a disability claim because you are high risk, but your employer requires you to work in potentially unsafe conditions during the COVID pandemic? Well, Moselle and I can probably field this one. I think probably more up my alley, since you have to be disabled for a certain amount of time to be eligible for Social Security benefits. I don't know if we've been there long enough yet. I am starting to see people file claims based on this reason. You have to look at the terms of your policy. The answer to the question is usually technically yes. I believe the way most of these policies are written, you should be able to. However, not all judges nor insurance companies agree with that interpretation. A lot of insurance companies will take the position that the policy says we pay you if you are unable to do your job. You are able to do your job. You are just choosing not to protect your health. It sounds like an insane argument, of course, but this is actually the argument they take, and because this is what the language says. So I can't recommend that anybody make a disability claim and expect it to pay out. It's worth fighting, most certainly. But of course, I wouldn't advise you go to work and risk your health either. If you're in certain states, you could also look for state disability. They may be more prone to paying compared to private. Moselle, are you seeing anyone making Social Security claims yet?
No, not yet. As Andrew was saying, you have to prove that your condition is going to last for at least 12 months in order to be eligible for Social Security benefits. State disability, you don't need to show that. So state disability would make more sense in this situation, at least right now, especially if you're in, say, California. And also with the CARES Act, state disability is actually, they're paying for a lot more things. For example, if you can't go to work because of the risk of being exposed, or if you have been exposed, so you have to quarantine, then you're able to get either disability or unemployment type of benefits in California, and I think that should be in other states as well. But in terms of doing an application for Social Security disability because you feel you can't work because you're at high risk, it's the same answer as it is in LTD. Social Security has their make-believe world. So if you can physically and mentally do a job, then you are not found disabled. They do take it into consideration to a small extent. For example, you'll see that if you cannot be exposed to really hot or cold environments, they recognize that. So maybe it will evolve that they'll start to recognize this as a risk, but I feel as of now, I don't know. That would just be on a case, judge by judge or Social Security office by Social Security office, because I really can see them saying, well, someone with hypertension is maybe at more risk for COVID infection, but, you have controlled hypertension, why can't you work? So I don't know how it's going to pan out. Maybe in the future that would be.
Yeah. So, if you are in that position where you can't work and your employer is forcing you to work, I think if you have disability coverage, private disability coverage, I think it's certainly worth making a claim. Again, it's not worth relying upon. Your medical choices should be totally separate from the disability decision. But it's certainly something worth fighting about, especially depending on the language of the policy. It's a fight that's been fought in a lot of other situations in the disability world with different results depending on where in the country you are. For example, the usual adage is someone with a heart condition, their doctor restricts them from a high stress job. Say, okay, well, I can't go back to being a lawyer. My doctor says I'm, at risk of a heart attack. Insurance company says, we don't care. You can physically do your job. And, depending on the judge, depending on the facts, it goes one way or the other. So it's worth filing, but it's hard to say how it's going to shake out, especially since we haven't been filing the cases yet. They've just been coming in.
Yeah, I would say just a little caveat. It's possible that if the risk of exposure is so great that it causes such severe anxiety for an individual, it might be something that would be worthwhile, I guess, for Social Security, because if your past work was high skilled work and you can't do your past work, once you get to a certain age, then you would be found disabled in a Social Security context. But of course, as with any other medical condition, you have to document, always document. So if you're having severe anxiety, you better be seeing a psychologist or psychiatrist to document that the anxiety is indeed disabling you, keeping you from working. Andrew, you're muted.
I need to remember to turn that off. I got one comment that there's a little bit of echo from us. So when we're not talking, we should mute ourselves. And unlike me, remember to unmute when you're about to speak. So I'm getting a lot of questions. Thank you all for sending your questions in. A lot of them are MECFS and Social Security related, not really anything more COVID related. So we can kind of pivot to that. So let's see. One question I've got, so with MECFS, many lab results come back normal. What are some important tests that can show abnormalities? I think we can all chip in on that one, but start with the doctors, of course.
I write all the reports for Workwell, and a couple of years ago, I decided that, I considered that the credibility of the report would be strengthened if I didn't know what the person was diagnosed with. So when I write the reports, I don't know what the diagnosis is. Usually I can guess, but I'm never told up front. So we go on the data. So we go on objective data, and if the objective data can be shown to indicate disability, then that's really all you need to do, because a diagnosis alone is not going to get you your disability. So whatever you diagnose with, it could be bubonic plague, it could be terminal cancer. If you're not shown to be objectively disabled, they're not going to file the claim. So any objective test that can show impairment is going to be helpful in a disability case. In terms of diagnosis, there's no diagnostic test for MECFS. So any other test that you have can help document symptoms. So things like a tilt table test is going to document orthostatic intolerance. Orthostatic intolerance then can be extended to indicate an inability or an impairment in a work situation. And so then if I also see something in the CPET report that substantiates that orthostatic impairment, then that starts to build the case.
Well, aren't most providers using the 2015 IOM definition, and orthostatic intolerance? Isn't that one of the requirements that are cognitive impairment? So that, that's how it could also help, is you can get a tilt table test to show orthostatic intolerance, which helps you show, prove the 2015 IOM definition. Dr. Dowell, you're still muted, but I think you, weren't there some tests that you were aware of that, I think Dr. Bateman.
So, in fact, I did, you'll see in your packet, I put in, there was a paper that was just published today, and it's about documenting disability and MECFS. So it's great. It'll tell you some labs that may show some abnormalities. It did talk about documenting orthostatic intolerance or cardiopulmonary exercise testing. But I guess the bottom line is any symptom that you're having, I would follow through. For example, if you have sleep impairment, I would go and see a sleep specialist, sleep medicine, so that they can document, sleep impairment. A lot of times patients will have sleep apnea, or maybe they might be a little hypoxic. So you have to sort of determine what are your symptoms in the disease, and then follow through and see that specialist to try to get some kind of documentation for it.
And as far as it relates to disability, Moselle, how important is it to a Social Security disability claim to actually have a diagnosis or a confirmed diagnosis, however that's defined in the Social Security world?
Well, technically you don't need one, because you just have to show what your limitations are and have them well documented, as Dr. Dowell is saying. However, it's always helpful to have that diagnosis. or a diagnosis. If you have that, Social Security does have a ruling on how they will evaluate ME/CFS, fibromyalgia. So it is always helpful. It's not necessary, but it's helpful.
It's, yeah, it's pretty much, it's kind of the same in the private insurance world. The one caveat sometimes though, if you have private disability insurance, check your policy for ME/CFS or chronic fatigue syndrome limitations. Unfortunately, I'm seeing them a lot more frequently. It used to only be mental health limitations, and allegedly was because mental health limitations are hard to prove because they're all subjective. So insurance companies have tried to go a step further, and of course, limiting coverage wherever they can. They're limiting chronic fatigue syndrome. Now, how they define that ranges from, I saw one policy which literally said chronic fatigue syndromes, period. No, nothing else. And I've seen some which say pretty much are a 3-paragraph list of anything that's ever been related to a fatigue disorder. So it really does vary, but that can end up being important. It also can end up being important, which is extremely common if you're on disability and you have ME/CFS and the insurance company has decided, yeah, we'll pay you, but according to the 2-year mental nervous limitation in the policy, we just think it's depression. So in that case, being able to prove you're actually disabled from ME/CFS, especially at the time that 2 years is going to run, can be extremely important. It can be the whole case. Now, of course, it just depends on the policy, and usually you don't need a diagnosis, but it's a lot easier to explain where your symptoms are coming from if you've got a diagnosis that confirms it. So those are some of the things you can do to prove your diagnosis if you need to do that. Let's see.
I'll just fill in quickly because I did see a comment from somebody who I know. I won't mention the name because we're all anonymous. But she did mention that neurocognitive tests can document impairment. She also mentioned natural killer cell tests, which can help with the diagnosis. I'm not sure that an immune dysfunction is going to prove impairment, but it can help with the diagnosis.
Okay, so
neurocognitive certainly does help. Unfortunately, they're not cheap.
Got it. Okay, so let's move to the next question. So a lot of these questions are up Moselle's alley, a lot of Social Security questions. So so I went through all the appeal steps and was still denied. The judge did not review all the evidence. Should I bother starting over? You're muted. Hold on. I can ask her to unmute 1 sec.
Okay, so that's a good question. I definitely wouldn't give up fighting for what you need. However, you may not want to completely start over if you've been denied by the administrative law judge. At that point, you can't do a new application and appeal at the same time. So that will be something that each individual has to determine if they want to appeal it or just start over, do a new application. But generally, we recommend appealing it to the Appeals Council. Unfortunately, the Appeals Council has a high rate of affirmation of the ALJ denial, so basically denying you again, which means then you have to go to federal district court, at which point you can then file a new application while your old application or first one is pending. The reason why we generally recommend appealing it rather than just starting over is in the Ninth Circuit, it's actually a little more difficult than in some other circuits in that if you do a new application, you kind of have to prove that you've gotten worse since the judge denied you. And for a lot of individuals with ME/CFS, it's pretty hard to show that you got worse. It's kind of a legal fiction. Well, the day after the judge denied me, I got worse, or a month later. But usually people who I've talked to, it's just been bad. And maybe it continues to deteriorate, but it hasn't necessarily been getting worse. So that burden might be difficult to prove. So unless the person says, hey, I just can't wait, I want to try again on a new application and hope that I get approved a second time faster, I really need the money, there's that consideration too, but I usually recommend appealing it.
And, along those lines with private disability, if you are denied, it's kind of related, make sure to appeal, especially if they give you a deadline in the letter. If you do not appeal on a timely basis, you risk waiving your right to file a lawsuit. On the flip side, if you file late and they deny you, don't necessarily give up. There are ways around it if the policy is written the right way and there's a few good facts, but do try and appeal in a timely fashion.
I agree. Just a real quick thing, definitely appeal in a timely fashion. If you miss the deadline though, definitely try, because if you're dealing with ME/CFS, you cannot, and for Social Security cases, there are part of the regulation states that if you have a cognitive or mental impairment that kept you from timely appealing, that would be good cause possibly. So definitely, even if you've missed your deadline, you might as well try.
One quick thing just to throw in.
Oh, we have another COVID question.
I was going to say, Andrew, did you want to just make a distinction between appealing a court decision and appealing an insurance company decision?
Oh, sure. Yeah, that wasn't clear. And what I mean by appealing is when the insurance company sends you a letter denying the claim, they will give you rights to file a administrative appeal, which means an appeal with the insurance company before you file a lawsuit. And that's the appeal I'm talking about. If you don't make that deadline, you might not be able to file the lawsuit at all. Thank you, Dr. Snell. I appreciate that. And the information should be in the letter that denies the claim if that, unfortunately that happens. Okay, I have an SSDI hearing approaching, likely by phone due to location and COVID restrictions. Do you have any advice for the appearance as a CFS and fibromyalgia sufferer? I'm worried about having enough data to provide, although I have done the Workwell study. You're muted again.
The key thing that I obviously I'm biased, but I think our studies are a powerful argument, assuming that the evidence supports impairment. But where it's not worked is generally when the judge doesn't read the report and is not forced to read the report. So it just needs to be stressed that they need to read the report, and any other evidence that you can provide, even if it's anecdotal from family members or people that you've worked with, all of those things are going to be helpful. So try and load the argument in your favor. So I don't think you can have too much.
Moselle, what do you think?
No, I agree. The more evidence you have, the better, which is why we always tell people, even if your doctor has told you there's nothing more that you can do, which generally isn't the case with ME/CFS. People are usually seeing their doctors. It's just so critical to go on a regular basis or have a telehealth appointment on a regular basis. Just so it's documented in the records, multiple occasions, all of those symptoms that you have. And as well, if you're able to get a copy of your medical records far in advance of the hearing so that you can see, did the doctor actually document what you were telling that person? Sometimes doctors, don't, because the purpose of their medical records are just for themselves to keep their own notes, jog their recollection. Unfortunately, for LTD, for Social Security, we need those things written down in the records. So.
Great, thank you. Next question. For our private LTD claim appeal, the medical reviewers ignored or didn't understand the CPET results from Workwell Foundation. Not the first time this has happened. Any tips on how to help the medical reviewer understand the CPET results and how it shows physical disability? One of my strongest cases has a letter from Dr. Dowell and a letter from Dr. Snell, and that's the best way to convince them. It's just getting, if you have a CPET study, or you have any other, independent study or an IME or something like that, have Dr. Snell or his equivalent write a responsive letter, clearly explaining what they've bungled, why they've messed it up, what logical errors they've used, and you go to your treating physician and you hopefully have him or her do the same thing. Dr. Dowell, I mean, you've written lots of these letters before, I presume. What do you think is the kind of things that you include that have actually been persuasive?
Well, I try to approach this more proactive than reactively. So I just try to collect data, have the patient collect data, so that when the time comes, we have something to show, right? So I agree in keeping records. And, one of my thoughts are if the physician that's treating them is not good at record keeping, they can bring in a copy of here's what's better, here's what's worse, and just hand it and ask it to be put in their records, So that's a way they can kind of get around that if their physician's too busy. But it is definitely a dilemma because it's time consuming and it's hard for just primary care providers to write these letters and these rebuttals. And so it really does, at that time, benefit you to go to a specialist.
Dr. Snell, you've written a few of these rebuttal letters, a couple for me, once or twice. Are there any,
I'm going to fill the rest of the
own
webinar if I'm not careful, Andrew.
Yeah, right. Any tips on how to do this on your own and get it into their heads on how CPET works?
The problem is that the independent reviewers are very seldom independent, so they're going to say that you're not impaired, you're not disabled. The upside is they don't do a very good job of it. It's generally a sideline for them. They probably have somebody in the office write their review. And mostly, if it's 20 pages, 15 pages will just be detailing items of a list of things that they read on your medical record. But they don't always even read the medical record. I always ask for that so that I can go through it. And I will try and find things that they get wrong or things that they've missed. If it comes to arguing CPET, is that you can explain this is where you're wrong. And this is why. It's not that difficult to do, other than it's quite stressful to actually go through and write the rebuttals. But it's a hardship for the patient. It's time, and it's unfortunate. Andrew can probably attest to this. We've even had cases where I've written a letter, sent it to the independent medical review, and they've turned around and agreed, and then the insurance company have still denied the claim. So,
you send a 10-page letter after you send a 2-page letter, and they say, oh, there's no new information in this new 10-page letter, so we're just not even going to send it to our doctors. We still to this day don't know how the person concluded 10 was equal to 2, or that it couldn't have had new information. But these are the kind of things that a lot of these insurers just do. We're losing Dr. Snell over here. Hopefully get him back shortly. There he is. But another thing is, as Dr. Snell was kind of saying, don't necessarily expect to be able to convince them. I send in, with every CPET I submit for a client, 600 pages more now of peer-reviewed studies going back, a decade or two, including the ones that are from 2020. I mean, we update it all the time. Explaining how great CPET is and why it's efficient and why it works. And without fail, we will have confirmation from the doctor they never read it. And at least some part of their logic that was wrong is it clearly explained in the documents we sent. And they never review them. I mean, it's not worth their time, so they think. So, it really is, the things you do and you kind of set them up, but really they are doing everything they can to figure out a way to deny you, especially if it's an ERISA claim, because the insurance companies don't really face any real risk for doing so, because there's no extra contractual damages. And there's a lot of other things which make it really hard to litigate. And, so this is, I would not be shocked if you get a denial no matter how good your evidence is. But if you do have a CPET, get a letter from Dr. Snell, because that's the best chance you have. And if you have an ERISA case and you're doing this pre-litigation appeal, you probably will not be able to get evidence in during litigation. So it's really important that you do respond and get all this stuff in beforehand. And if that means contacting an attorney before you do this, then I certainly recommend that. Definitely one who offers free consultations, not one who's going to charge you hourly or something like that. So we can move on to another question. I like this one. Are tilt table tests more validating than the standing test?
Well, tilt table tests are considered the gold standard, but there's evidence that a stand test is like 87% sensitive, which is actually more sensitive than the tilt table test. So I would say that if you're going to use a stand test, that you just have the documentation that shows that it's more sensitive, and it's out there. There's documentation out there that says that.
I would agree with that, that tilt table test is, people say it's even more stressful than doing the 2-day CPET. It's another expense. Any competent general practitioner should be able to do a standing test as part of their workup in the office, and then they can write that up, and that should be enough evidence. You should actually not need the CPET, the tilt table test. And I know Dr. Bateman routinely does the standing test and gets good evidence from that. We very often get support for orthostatic intolerance just from the CPET. And over the last few years, I will include that without commenting on it. I just say that this aspect here can support orthostatic intolerance. So if it does come back round again, that's been documented. And if it's documented somewhere else with either a tilt table or a standing test, or just recorded symptoms over time, if you've been going to the doctor for the last 10 years, with dizzy spells and that's a documentation of orthostatic intolerance. So it all adds to the argument.
Thank you. So this is a question for Dr. Snell. I'm actually interested in this one. So the question is, I did my CPET and with Workwell, and the report said that if my heart rate goes above 105, I will crash. Can I send in my own data that I have with my heart rate tracker where I've tracked a 5-minute walk, a shower, etc.? Would I send in raw data? So maybe this is actually a question for Moselle and I. Well, I guess first, Dr. Snell, would data like this confirm or validate results from a 2-day CPET?
Just a disclaimer, I don't actually say in the report anywhere that if your heart rate goes above that, you will crash. But what I do is I will recommend heart rates that put a person at risk for exacerbation of symptoms, and that will go in the report. So I will say the person should not exceed this heart rate and should avoid exceeding this heart rate whenever possible. And that will be based upon the CPET data. Now, if you have supporting evidence from that, so it could be self-report, but generally self-report doesn't carry a lot of weight. But if somebody else will say, well, whenever my wife or my husband or my brother or my sister does this, they experience these symptoms. Also, running a heart rate monitor is useful. So what you can actually document is that, for example, if I stand at the sink and do the dishes, I exceed that heart rate. And that starts to put it in perspective, because the idea is that it's simple tasks that are a part of activities of daily living that will exacerbate symptoms. You're not going out and running 10 miles. All you're doing is having a shower, and you've already exceeded your heart rate walking up and down stairs. And we know, anybody that knows anything about ME/CFS knows that people have a very low tolerance for physical activity, and normal activities that sound ridiculous in terms of making somebody sick. For somebody with ME/CFS, they will make somebody sick.
So if I could add to that, yeah, any one of the big problems, at least for the private claims, disability claims, is that the insurance company always says, you know, your complaints are subjective. Now that shouldn't be enough for them to reject, in my opinion, because if they have no reason to dispute your credible complaints, but anything to verify anything else that you have is going to be helpful. You know, for example, the insurance company does surveillance of you for a week and they actually see you not leaving your house for a week. That can help you. It's, you know, it's just something that corroborates what you're saying, and your credibility is just critical in a disability claim. So the first thing I'd say is that if you've tracked anything, if one of anything is not going to be enough. They'll just dismiss it as an outlier, or, you know, that's the one time you had a bad day. If you were to track this regularly and then somehow verify that, you know, you are exceeding this dangerous rate every time you do something, or your body's experiencing some other kind of, you know, impairment when you're doing these minor activities, video plus heart rate tracker, however you figure to do it, all of that could be helpful, at least I think in a private disability claim. In a private disability claim, you can send in anything you want. There's no limit. There's no rules about it. You can literally send in anything you want. Not so you should, but you can. Moselle, is that the same in Social Security disability, or is there?
I mean, it is the same. You can send in anything. Whether the judge will give it much credit or weight is another story. I think, though, that it might be useful to start doing that. And the reason I say that is we can analogize to, say, the migraine headache type of disorder. And cases now with migraine headaches, judges are actually looking at migraine headache journals. And of course, it is subjective, your level of pain. They can't feel what your pain is. We're not in academic settings where we can do special types of PET scans to, you know, see that different areas of the brain are lighting up because of your pain, what have you. But I think it's worth a try. Again, as Dr. Snell said, though, you know, getting input from a spouse, you know, friend, a parent would also be helpful to corroborate it. The more you have to corroborate your own subjective or your own evidence, the better. And the more frequently that you track it, the better as well, to show that this is a consistent pattern. But I think it's worth trying. It's something that they're doing for migraine headaches, requesting that claimants have migraine journals. So why not?
Yeah, one thing that I do see is that very often these reviews imply that the patient is telling lies. Very rarely will they come out and say that the person's telling lies. Mm-hmm. So if I'm responding to that, one thing that I try and do is I put a lot of pressure on anybody else that's reading the letter that I've written to turn around and call the patient a liar. And so the more evidence you can present and also push that envelope, the assumption is that people tell the truth. Mm-hmm. And if you say you're sick, you really are sick. And, you know, and here's 25 different aspects of this illness that this person is telling us about. Are you going to say that all of these are lies? So it makes it very difficult for somebody to turn around and do that and look good. So I'm trying to set that up, that they've got to turn around and not only, I mean, people will call me a liar, but even that can backfire. So, but I found they're very reluctant to actually come out and say that this person's making this stuff up, but they do imply that very heavily.
Yeah, they imply, because it's the only way they can actually defend their position, because they have to say everything you're saying is untrue, because what you're saying is you're not able to work. And that's why credibility is so important. And that's why these, you know, we call them liars for hire in our office and in other offices, you know, are so willing to insinuate that the claimant is exaggerating her symptoms, or, you know, if they're politically correct, there's not enough evidence in the record or objective examination evidence, because of course you can examine and see ME/CFS visually, to support your claim. And so, you know, the theory, I mean, the basics of it is most people who apply for disability don't want to be on disability and would rather be working. So they're actually disabled. Thus, the only way an insurance company comes to the opposite conclusion is if they screw something up, or they lie, or they, you know, turn truth into a lie. So kind of keep that in mind as you're dealing with your private insurance. And, you know, speaking of kind of private insurance, I'm seeing several questions about surveillance that we can kind of answer. So first, I know of no laws which, well, let's do it this way. Hey, Moselle, do they do surveillance for Social Security or SSI? Or is
Yeah,
it just...
good question. It's not very common, partly because, you know, they don't have a whole lot of funds to throw at it. So usually they'll only do surveillance for Social Security if somebody has tipped them off to possible fraud. So that's usually the only time they'll do that in Social Security. However, a lot of times my clients have other cases going on, such as workers' compensation. So there might be surveillance going on with the workers' comp case. And then the problem with that is that surveillance is inevitably going to be in the medical records. It'll be discussed, which then ends up in the Social Security file. So that's how we usually end up seeing surveillance. And, you know, usually the surveillance is pretty ridiculous. I just had a case a couple months back where it actually proved how disabled the client was. So they're trying to catch people. But this actually, I think there was another individual who was wondering whether their social media accounts could affect their claim for Social Security. Definitely. You know, it's really sad because you might post something on Facebook, let's say, and you look great, but the judge or whoever's looking at it isn't going to see how you felt after, if you had to lie down in bed for the next 2 days because you did something that was, quote, normal. However, it could be taken out of context. So I'd be very careful what you post on social media if you're trying to fight for disability benefits.
Thank you. And, you know, to kind of, you know, to add to that with the private disability, they don't always surveil you, but you should always expect that they are going to surveil you. It happens all the time. It happens often enough that you should genuinely be worried about it. I'm sorry, you know, to say that outright, especially the first 2 years, or if you haven't been paid yet, or if you've just recently been denied and they expect you to appeal. There's a few easy ways to protect yourself. The easiest way is just being honest, is to make sure you never say, I'm never able to go on walks, when you sometimes are. You know, it's like, I'm never able to go outside and garden. You say, on my good days, I have really, you know, I can do all of these things on my good days. They're not very common. And I do everything I can on a good day because they're so rare, and because my doctor told me to do these things. So if you're telling the insurance company all of these things up front, you're laying the groundwork to protect yourself. You know, so they can't take this little snippet out of context, you know, and try and use it against you. It's one of these few upsides of, you know, an MECFS claim compared to someone with, say, a back injury, you know, because it's a lot easier to take someone, you know, lifting something out of a truck and saying, wow, they said they can't lift more than 10 pounds. Look at them lifting more than 10 pounds, compared to someone who has, you know, good and bad days. I don't know of any laws which, at least in California, which restrict their surveillance outside of regular trespassing and privacy laws. I wish there were such laws. I really do, because the extent to which they can kind of intrude sometimes is really, you know, it's a little obnoxious. They only do it for a few days at a time. And it's usually not that intrusive to try and catch you going to the store. If they send you for an exam, you will be surveilled. They watch you go to and from the exam to try and catch you, you know, and walking in a walker going in, and then, you know, tossing the walker over your shoulder and, you know, skipping out of there, which of course just about never happens, but that's what they're looking for. So it's something definitely to worry about with a private LTD claim, but thankfully, at least not yet, doesn't seem to be too big of a deal with Social Security. And, you know, one thing you can also do if you are caught on surveillance and the insurance company is using it against you, you know, have your doctor or, you know, your expert write a letter explaining, you know, this is not out of, you know, not out of sync with my opinions. Now, and it's especially important to do this with your treating physician who's been certifying your disability, because one of the only arguments that can actually work for an insurance company, if you have a lot of support, is them saying, well, she or he has been lying to their doctor the entire time. So the supportive doctor is also being hoodwinked. And look at the surveillance. This is totally contradictory. And so they try and paint it so that your doctor's opinion isn't even credible because you've been, manipulating the facts. And so having your doctor say, no, this is not inconsistent at all. Actually, this confirms what she's been saying. It can be very helpful. So also something to keep in mind, thankfully they don't usually do too much surveillance once the 2-year mark is passed because it becomes a lot harder to cut you off. But again, I would always presume that they might, and always make sure you're being careful when you speak to them, being honest and qualifying what you say, and explaining in full your good days. So
and get a copy of the video.
Yeah, oh yeah, of course.
Because we would review that and pick up anything that needs to be picked up on.
Yeah, so let's see. We have another one. Oh, so okay, I got this. I feel like I've submitted everything I possibly can for my MECFS claim. I have another opportunity to submit evidence. I'm trying to find something new. Is there any new evidence of fatigue or cognitive impairment or MECFS that I might not know about that I could send in? Dr. Dallas, might be a question for you. Maybe. You're muted. There you go.
Well, I'd have to see what they've already submitted, but I would do labs because there might be some change in labs, and that it is really true. Looking at the immune labs sometimes can give some supportive evidence. And there is, when you read this disability document for a physician, it shows that they'll sometimes even accept viral labs. So viral loads that a patient might have, they might accept that too. So I would look at that, but I would just make sure I had neurocognitive testing. That's true. I would try to make sure I had a tilt table or a 10-minute stand test. I would sometimes even for patients, we can do cardiopulmonary. Other than the CPET, also do pulmonary testing, sleep studies. You just try to be thorough in what you do, and then keep a really good diary of what you're doing.
Dr. Snell, do you know anything new or cutting edge?
In terms of testing, well, if it's new, then it's probably not going to be accepted by the court, right?
If you're, anything brand new, you don't want to rely upon exclusively, but, I like this person's attitude, because you never know what's going to, push them over the edge. And, even if you're not going to convince the insurance company, you want to do everything you can to, convince the judge who will eventually see the case. Yeah. If you're at that point, and if there's an opinion to be attacked, I'd make sure to attack it if you haven't submitted any other evidence. But besides that, make sure you find
one thing I would suggest to people, if they're insisting on doing it themselves, is use the CDC website. It didn't used to be very good, but since the IOM report, essentially the CDC website now is modeled on the IOM report, but it's much more accessible. They've got patient stories in there, and so although the CDC is not quite as credible as it used to be, but it's still a pretty credible organization that most patients are not going to be able to access primary research data and interpret it in such a way that then they can translate it for a judge or a court. But the CDC website is technical enough, but it's also accessible enough to be able to take arguments out, documented symptoms, and you can use that to support what's happening to you. So it's fairly straightforward. It's just an internet search, and you go in there and you can look stuff up and bolster your argument with it. Great.
Next question. This one will be for Moselle. I keep mentioning including studies or official explanations to justify or explain certain test results. Is this applicable to SSDI? I am 2 years into my SSDI case and I'm now waiting for a hearing date. I've had a tilt table test recently proving my POTS Is it enough to just submit the test results, or should I be submitting supplementary info to explain or validate this test? Good question.
You know, it's a good question. I say, why not submit it? Because it's possible that the judges are completely unaware of these tests and, you know, why they should be relying on these tests as persuasive evidence. So you might as well. Some judges won't look at the explanatory material, some will, but it never hurts. I remember early on as an attorney, I actually submitted something, and, you know, lo and behold, the judge actually changed his opinion based on what I submitted. It had to do with marijuana use, and this was probably about 10 years ago, and I decided I didn't want this claimant to, you know, I didn't want that to affect the client's outcome, which it shouldn't have, and the judge really did take a look at my articles on it. So I think it doesn't hurt. You never know.
Great. Okay, next question. We have a few questions about the hearings. I mean, I've gotten in different forms, but how important are the Social Security hearings compared to the evidence?
I'm sorry, say that again?
How important are the actual hearings compared to the evidence submitted beforehand?
That's a very good question. You know, I think the evidence in some ways is a little more important, but, you know, this is the time that the judge is trying to assess credibility, and otherwise they would have made a decision without having the hearing just based on the evidence, which sometimes they really should be. There's no need for a hearing, in my opinion, on a lot of these cases. However, I really think it's the judge trying to just size the person up, see how credible they are. And in a case like ME/CFS, where some of it is going to be subjective, especially if you haven't had some of these amazing tests done, such as CPT, sometimes I have clients where, you know, they're talking about their symptoms, their excessive, extreme fatigue and post-exertional malaise, and, you know, they're going to discuss that, but, you know, the judge is trying to decide, well, do I really believe this person? So I think both are important.
Great, thank you. Okay, here's a health insurance related question. You know, I have ME/CFS and I've been working with Stanford CFS Clinic, and I'm on SSI with Alameda Alliance, and I've had a lot of problems getting out of network doctors approved. Can we get help with rejections of coverage to go to the Stanford Fatigue Clinic when there's no other chronic fatigue doctors in network? Is being on SSI with Alameda Alliance, does that mean Medicare?
Yeah, I'm not sure. Let me see.
Okay. So assuming it's private insurance, you know, you've got to look to your policy to see what is allowed and what isn't. Certain state laws will have regulations about what they're supposed to provide as far as out of state, but.
Okay, Alameda Alliance.
You with us, Mozella? You're breaking up there for a second.
Oh, no, I'm here.
Okay.
Is my
Alameda
video
Alliance is the medical. Okay.
Yeah.
Okay. You know, if you have a copy of your policy, make sure to take a Medi-Cal. Is Medi-Cal? It's not Medicare. It's Medi-Cal. I am woefully uneducated about Medi-Cal, unfortunately. Do you know anything about Medi-Cal, Mozelle?
You know, not a lot, just anecdotal. I know I have an individual who had a very complex case, orthopedic case, and she was finally, after fighting for quite some time, able to get out-of-network coverage. I'm not well versed in that at all, though. So I think it might be possible, but I know you'll have to fight it. It's difficult. Also, I think that they'll probably say they have someone who is within whatever 30 miles that is qualified to treat someone with ME/CFS. So that's also where the problem goes, too. But it's worth trying. I'm not sure though.
Yeah, and you know, email us at benefits chat after, because I think you know, we have a whole a team that does health insurance denials. I don't do them nearly as much, but I think we know someone who knows a lot about Medi-Cal who might be able to answer your questions. So yeah, please email us after the fact. I'm pretty sure you know whose questions we're answering. So, all right, so let me just run through this. Okay. Sorry about that. Multitasking. Okay, we've gotten a few questions about once you've been paid, what happens next. So, you know, one question is, once you've been approved for either LTD or Social Security, do you need to prove your disability again in the future? Well, Moselle, you go first, because I don't know I don't know much about the process for SSDI.
Yeah, good question. You know, sometimes the Social Security judge's decision will tell you that they're going to review your case in a certain amount of time. Sometimes they'll say a year, sometimes 2 years, 3 years, 5 years. Sometimes they won't say on that letter. Usually if it doesn't say, they review it every 3 years, which means you have to continually get updated treatment notes, or at least go to the doctor, so that if you get reviewed, you don't get kicked off the benefits. At that point, if you have not been going to the doctor and you get kicked off, it's going to be really hard, and then you end up with what they call a cessation case. So definitely with someone with ME/CFS, I think that they usually would be a 3-year cycle of review.
Yeah, so as far as private disability goes, they're a lot more aggressive. You know, this particular question is asking, you know, do you need to prove your disability again in the future? For example, at the 2-year mark, yes, but you need to be proving your disability constantly. You know, insurance companies, private insurers can check in as often as once a month. They're not usually that obnoxious, thankfully. It's usually something like 3 to 6 months. But they're constantly asking for medical records, for updates. You know, they want to kick you off claim as soon as they can. So they're not going to, you know, wait 2 years and see what's going on. The 2-year mark is significant because often the definition of disability changes from where you not only have to be unable to do your own job to be disabled, you have to be unable to do any job, and any job means any job according to the terms of the policy, which doesn't actually mean any job, but that's, you know, another topic. But there's a lot of ways they can try and cut you off after 2 years. That's just one opportunity. You know, again, the likelihood of them cutting you off does decrease the longer you are on claim. There's no doubt about that. But I'd be lying if I, you know, said they hadn't come sniffing around again 10, even 15 years later when people were clearly permanently disabled, and, you know, trying to conjure up a reason for a denial. You know, if you want to read an interesting lawsuit, Fleming v. Unum, from Judge Carney, she actually only made it through one of the 2 days of CPET. She had a bunch of other evidence too, but the CPET was found supportive even though only 1 of 2 days was completed. But she was on claim for, I think, 12 years, and they saw her very slowly throw away a empty trash bag, which was full of empty water bottles. But they said, oh, the trash bag's full of stuff, and so they assumed that she was throwing something heavy, and boom, she's cut off. But why were they even doing surveillance 12 years later? So I don't know. It happens, unfortunately. And so you have to kind of, when you're on disability, be always mindful that, you know, it's never a set entitlement. They could always come back asking for more, you know, reaching out to your doctors. And that's another thing is, you know, keep your doctors in the loop. If the insurance company or SSA reaches out to you and says they're going to be getting records, you know, because if they're getting records, there's a chance they might also be getting a peer review. And often they'll send these peer review documents to your doctors, not warn you, and then, oh, they didn't respond within 5 days. That must mean, you know, in some places they still say that must mean they agree, but they can't really do that in most courts. But they can try and use things like that against you. So it's really important to keep your doctors on notice. What committees in Congress oversee SSDI? Do you know the answer to that, Moselle? I don't.
I should. I'm trying to think. You know what? I'll have to get back to him that I don't recall.
Yeah. I hear a similar question is, you know, once I've been paid and I'm on claim with the CPET results, is the insurer ever going to ask me to do the CPET again? The insurer is never going to ask you to do a CPET ever. They're never going to ask you to do a CPET because they know chances are if you do a CPET, it'll come out supportive. I've never seen an insurer ask for a CPET, especially a 2-day CPET. If that ever happens, please email me directly because it'll be a special day for me, right? I mean, for Dr. Snelks, it'll be a very special day as soon as insurance companies actually agree to start sending people to this. But you should expect them to continue to do all the things we were describing. You know, they're going to check in with your doctors. They might surveil you every so often. They'll call and ask for status updates. They might send you to an IME, an independent medical exam with a physician, which is sometimes appropriate for people with certain, back conditions, shoulder conditions, mechanical issues. I still don't think I've ever seen an insurance company IME doctor look at someone and say, yes, I can tell they have ME/CFS, claim approved. You know, it's a setup pretty much for people with ME/CFS and other such illnesses. So they'll keep surveilling you and doing whatever. They're not going to ask you for a CPET. So I will hope one day they will. Here's one. I am having trouble with my doctor. She is not educated in ME/CFS or any of my other illnesses, and I don't really have the option to go anywhere else. How do I tactfully get her on my side before I file my claims? Dr. Dow how do we persuade you?
There is fortunately now a lot of information on the internet about ME/CFS. And so in that packet that we have, there'll be a paper that talks about how a physician can diagnose ME/CFS, the differential diagnoses. I would bring that with them. Plus I would bring a self-reported, I'm experiencing this and this and this. So in a sense, you're going to be guiding and leading your physician. One of the biggest challenges is time for them, and that's why they don't like it. So if you could minimize it, come prepared with your health history, your labs, and try to make it as efficient, your appointments as efficient as possible, they'll start to I think they'll start to side with you. It's a real disease. It doesn't take much to prove that anymore. And especially with COVID, I think it's going to be easier than ever before to say, hey, I'm having these same symptoms. But that's my take. And that's what I hear from other providers. It's a time factor. It's not so much a belief. It's just complicated and they don't want to get involved.
Thank you for that. And I think that it's incredible over the last 5 years how, the number of people who don't have that complaint anymore. I feel like I used to have a lot of people saying, my doctor just doesn't buy it. What do I do? What do I show them? I'm getting that a lot less often now. And that's a wonderful thing. It really is. Before ME/CFS, it was fibromyalgia. No one believed fibromyalgia was real. And there's lawsuits about it throughout the country, basically saying the insurance company used a doctor who openly says, I don't believe fibromyalgia is real or ever disabling. You can't do that, so this is just the next kind of domino to fall in that regard. And, but it can be a tough scenario when your doctor is not on board. Moselle, have you had any luck helping people get their doctors on board or not?
Not really. I think it's difficult. Sometimes it depends. If they're willing to look at articles that you'll send their way, then great. If they're not, you may want to get, even if it's just a primary care doctor, just get somebody who you think would be willing to learn more about it. So even if it's not something they know a lot about, find someone who's more open-minded. But I agree with Andrew. This is becoming more recognized. Even in Social Security, we get a lot of cases denied by judges who don't understand it or don't think that these conditions are disabling, even if they believe the person has it. But those are cases where we are seeing a lot of remands, which means the case gets sent back down because the judge has made a mistake. So I agree with Andrew as well that this first happened in our field for fibromyalgia, I mean, it always happened for chronic fatigue syndrome, but I think there's more awareness now. So it's getting better.
Yeah, we generally get a positive feedback from physicians for the CPET report. So it's 2-3 pages that they can read and they can get information from. So and we're prepared to educate a physician up to a point if they wish to be educated. As you say, there's a lot of materials out there. You can just point them towards those materials, and if they're worth their salt, they will read them. And if they want to help their patients, you know, if you've got somebody that really doesn't want to help and is not interested, then probably you need to move on, because they're not gonna work out in the long run.
Mm.
Yeah. You know, one comment here. Someone commented, thank you for this. The film Unrest by Jennifer Gray of the organization ME Action has continuing education credits available for doctors. This is a good thing to offer doctors who are not knowledgeable or believing in MECFS. That sounds wonderful. I'm going to have to see that.
Yeah, no, I would second that. That's a great idea, because, you know, doctors are always having to do their continuing education, and, you know, why not?
Yeah. Let's see. Okay. Oh, this is interesting. I do out-of-state telemedicine with Bateman Horn. Had my first visit in person. I also go to an in-person PCP, but they do not have much knowledge on MECFS. Having mostly telemedicine visits affect my claim. Should I try to find additional specialists in the state? Since I don't know whether you're talking about private disability or SSDI, and my mouth's already moving, I'll tell you from a private disability perspective. It depends, but I think another upside of COVID might be that telemedicine is taken a lot more seriously, and doctors are put a lot more effort into telemedicine, as well as documenting, you know, the appointments. And, you know, with telemedicine, you could even record the appointments and send them to a disability company. Now, I know that alarm bells are probably going off in everyone's head about privacy. But if you get to the point where they really just don't believe what's going on with your doctor, it's an option. But I think, you know, 5 years ago, I'd say, yeah, you know, I got to look at the records and see what's what, and it depends what they're seeing in person and not, you know. And if you had like a back issue where the insurance company is expecting to see, you know, limited range of motion, pain on palpation, things that only a doctor in person could touch and feel, it'd be a different story. But since the telemedicine, you know, with MECFS, there's a lot less of that. You know, if the documentation is thorough and the visits are consistent, and your PCP, at least, even if they don't know a lot about MECFS, at least that, you know, accurately documents, you know, patient comes in, reports that she's still suffering from significant fatigue, you know, on exam, she had to sit on the table, and she had cognitive issues when I was talking to her. If they can at least document, not a lot, enough to kind of like confirm the narrative as you go along, so that there's some doctor who sees you in person to confirm what you're saying, I think it is a lot helpful. You know, it gives you a big boost, and it you know, closes one of those doors that the insurance company could try to walk through. In fact, I have referred people to one out-of-state specialist who has helped a lot of my clients out in Arizona, even though they're in California. So should you try to find additional specialists in your state, there's a downside to switching specialists, because when you switch care, like, you know, they have to get to know you, and you have to learn you all over again, and there's a chance they don't support you. So those risks, you know, if you find someone wonderful and you don't like your telemedicine specialist, maybe, but I would not go out and try and find someone else just because it's telemedicine. And, you know, keep that in mind as well. An additional specialist might not be an additional helpful specialist. And you can have 10 doctors who are helpful and one who's not, and the insurance company will point to the one who's not and say, well, Dr. X says you can work. Dr. X is a genius, so we're going with her. So it's something you want to be careful about. What do you think, Moselle, from Social Security standpoint? What do they think about telemedicine?
Well, you know, I mean, it's not something that we've had to deal with a whole lot until COVID. So I'm not really sure how judges look at it. I know certain things can be done beautifully through telemedicine, and other things are harder, such as in fibromyalgia, the tender points, you need to palpate. So, it'll be interesting to see. So I'm not really sure. But I still encourage everyone, make sure you keep doing these telemedicine appointments, because we need your symptom complaints to be documented regularly.
It's worth putting the irony out that the insurance companies are perfectly willing to accept an independent medical review where somebody spent an hour going through the medical records and determined that you're not impaired, but they won't accept direct evidence from people that have seen you or even seen you on a video on a video screen. So
yeah, I agree with
I have
that.
made that argument in the past. It seems a powerful argument to me, but
The list of ironies is long, and the insurance companies, it's so common, and there's so many judges who look at that. It seems abhorrent to me to deny someone's disability benefits and to reject their credibility based on their medical records and never speaking to them in person or examining them in person. Like, it seems like morally wrong. Judges throughout the country just don't agree with me. Not a big deal to a lot of judges. It's like, oh yeah, paper review. What else do you expect them to do? Send someone to a doctor every time? Oh, that'd be a lot of money for that poor company, don't you think? So it's routine. Now in the Ninth Circuit, there is a lot of good law out there saying that if you're saying someone's pain isn't bad enough based on their records, we're automatically suspicious of you, because you can't just dispute someone's credibility based on medical records. So. But it's one of those things that is long list of ironies with insurance companies. Well, Dr. Dell, so have you been doing a lot of telemedicine in the past couple months? Have you adjusted your telemedicine? Did you do it before COVID?
Yeah, well, I was doing just a little bit of telemedicine before, and now that's all we're doing is telemedicine, because our patients are at risk, so we don't want them to come in. And I did do a telemedicine seminar that came out of the state, and they said that there was a case, and I'd have to look it up, that said that telemedicine was to be acceptable as an in-person visit. And so, of course, and that was important in order to get reimbursed for the visit itself, But I think that's what we're seeing, and like the VA has not even okayed in-person visits yet either. So I think telemedicine is going to be here for quite a while, and it'll have to be an acceptable approach.
Are doctors doing anything to kind of offset issues like this? Are they doing anything, more thorough records? Are they doing, extra documentation? Could they? I don't know. It's kind of.
Not that I know of. They're getting really creative, though. You can do some tests just visually, right? So a 10-minute scan test for orthostatic intolerance, if you feel that the patient has some support there should they fall, you can do that, virtually. So you can get pretty creative, but, we're all just doing the best we can, so.
So that's our answer as far as telemedicine goes. Again, maybe another upside from COVID that who could have seen coming. Okay, let's see. Let's see. Regarding submitting supplementary information that explains the validity of a certain test, or what exactly a test shows, or how to interpret the results, do we have any resources we can direct you to? So I would, if the resources, we'll send you a lot of stuff after the talk, but for case by case, the first place to go is your doctors and your experts. If your doctor just gave you a tilt table test, ask your doctor for information about what it means. Because then, you not only get the information from the source, but you can guarantee that they know exactly what it means and can explain to the insurance company as necessary. Because, of course, the doctor knows what it means, but of course, as I'm sure all of you have potentially experienced, not all doctors know how to speak disability, don't know how to put it in disability terms. So, I don't know, what do you tell people, Moselle?
Well, Let me take a look, because I was reading part of this question and I wanted to make sure, but which part of the question do you want me to respond
Sorry, my
to?
dog just went nuts on me in the front. What resources do you direct people to if they're handling, cases on their own, or they need to kind of support the information they're sending in, or if you're supporting the information you're sending in?
Yeah, I mean, in terms of medical supporting documentation, or you mean other documentation?
I think supporting the medical evidence.
Yeah,
that.
Generally clients don't submit to Social Security supporting evidence other than the medical records. However, as I said, sometimes they do. And it doesn't hurt and it could help. So I haven't directed people to particular areas, but I think that directing them to the Workwell Foundation website would be useful.
We have some stuff on our website as well, but yeah, that's one of the places. If you have a CPET, you definitely want to start on the Workwell website. They're doing new stuff all the time. I think they just sent me another study today. I mean, there's always new stuff to be looking at. So yeah, it's always important, even if your doctor, again, go back to your doctors, and one of the best pieces of support you can get is support of your doctor of other evidence. So if you get a CPET, give it to your treating physician and make sure or if they've done it in the records, it's fine. Make sure they say, I reviewed the CPET. I believe in this test. It makes perfect sense to me, and it says disability, and I understand why, and I agree with that. I make that a rule when I handle my cases. I try and get as much cross confirmation of evidence as I possibly can. Because what they used to say about CPET is, a doctor doesn't administer the test, or it's not medically verified. And I found, first of all, it's wrong. Second of all, it's very easy to just dispose of if you just have the treating physician say, I agree with this, which they're all now willing to do for the most part. But yeah, so our website, the Workwell website, and the people who are helping you are all good resources. And as far as private disability, certain judges they're factoring in things like personal statements of family members, personal observations. We used to kind of think they were a waste of time and energy, and I'll have to ask Moselle her perspective when she pops back on as far as how it impacts SSA. But having that kind of confirmatory evidence, declarations from family, a self-declaration, these journals we've been discussing, diaries, all these things can end up supporting the CPET and supporting your other evidence indirectly. SSA pays attention to that stuff, right? Like supporting declarations more than private does.
Yeah,
right?
they do. It really depends on the judge, because sometimes they'll just say, well, this is lay evidence, and maybe they'll say, well, they're just biased, so we're not going to give it much weight. They're just parroting what the claimant has said. So on the other hand, sometimes I think it depends on the disposition of the judge. If they want to approve it, they'll use it to help your case. But I think that the more you have, the more evidence you have to hit them over the head with, the better. For example, if you have a prior employer who could write something, or coworker, I think that looks a little better. But you still might as well have something from, your son, your parent, your sibling. Those things are also helpful.
Great.
There's an executive summary of the National Academy of Medicine, used to be the IOM report, that anybody can download online. Either search it, or there's a link to it on the CDC webpage. I would always submit that. They can read it or not read it, but at least it's there. It's solid, scientifically supported opinions that this is a real illness, it's really disabling, and you need to take it seriously. So I think that carries enough weight without, and it's readable. It's not like a primary research paper, which probably most people are not going to find accessible unless you're a scientist, even a scientist in that field. But the IOM report, National Academy of Medicine report, it is technical but accessible with little summaries, highlighted summaries, little sound bites that you can pull out, and it's worth attaching that to as a support to any claim, I think.
Moselle, that brings up a question I had. Insurance companies play around with the proper definition of MECFS when it matters and when it doesn't, obviously often to suit their own end goal. And I can explain that in a little bit, but does the SSA use the 2015 IOM definition of MECFS, or do they not use it at all?
No, I believe they do. There is a ruling, 14-1P. I wanted to see when it was published. Well, the ruling was initially published prior to that, but from my reading of it, it seems that they do. And maybe Dr. Schnell, I think you had mentioned in the past something about that.
Somebody did remind me earlier, my colleague over at Stanford, and I think it's 2014 is the updated version.
Yeah, it was 2014, but it seems to me to be very similar, if not.
It's almost identical.
Yeah, that's what I thought.
It gives examples of objective evidence that includes tilt table, any abnormal lab results. It gives a synopsis, but it doesn't give it doesn't use a definition.
Right.
It actually looks like it still mentions the CDC definition, which is the definition of exclusion, right?
No, I'll add now. I love it when anybody throws that one up, Andrew, because it's no longer on the CDC website. They took it down.
Yeah, no, but you're right. It does say the CDC definition requires blah, blah, blah.
And the CDC mirrors pretty much,
yeah,
it's identical to the National Academy of Medicine.
Mm-hmm. And one thing I think is interesting, because this is something I deal with as well, is Gulf War syndrome, and that's they use as an example of MECFS. So I guess you are kind of getting these entities that maybe aren't, maybe the person doesn't have a great diagnosis. They're not really sure what to call it, but at least it is all encompassed in this listing, this ruling for Social Security.
They have a list of still similar illnesses.
Right, right. I have an individual with Gulf War syndrome who's vacillated between Gulf War syndrome as a diagnosis and MECFS, fibromyalgia. He's had all of them diagnosed at one point or another.
Okay, so that's the answer to that question. So let's see. So what can we do if traveling to get CPET and paying for CPET testing and report is a financial hardship? That is a good question. The first self-promoting response is if we're talking about private disability, find a private disability lawyer who's willing to advance the costs. Not all of them do. We do, but again, not all of them do. That's one easy way to, do it. You'll have to pay the firm back afterwards, but they advance the cost. The insurance company will not pay for it. And some clients have asked me, well, can I ask for insurance? What if my physician, refers it and I submit it through insurance? The problem with that is, well, it almost always gets denied because it's not medically necessary, because nothing for disability purposes alone will ever be considered medically necessary because doesn't meet the definition. And even if that were not the case, oh, sorry, I just lost my train of thought. Oh, I just completely lost my train of thought. Wow, that's wild. Where was the financial? Even if insurance. Okay, sorry. Wow. So they're not going to approve it. Even if they would approve it, You don't want to do it through the medical records, because if the test ends up being unsupportive, it goes in your medical records no matter what. And then the insurance company sees it no matter what. And, you know, sometimes the test does not come out the way you want it to for whatever reason. If you pay for it out of pocket, you know, you protect yourself, and it never has to see the light of day if it ends up not being supportive. And unfortunately, the insurance company isn't required to pay for it either. And right now, there's really only one place to get it, and it's in Northern California. The labs, Southern California is opening up again soon. Maybe, we're not sure. You're muted, Dr. Snell, so you know. I'll unmute him.
Sorry.
Oh, uh-oh.
Okay. Good. Yeah, we are open for business again, just. I'm not sure whether they're operating out of, yes, actually I did, because I was told this morning that we're actually going down to the center of the corona outbreak in Southern California next week. So that is available. I do know that our colleague on the East Coast is not doing testing at the moment. But we're trying to clear our backlog at the moment. Unfortunately, it costs what it costs. You know, Workwell has one salaried employee, and our CPET testing supports him and his family and helps with our independent research. But it's not a huge money maker. I would love to be able to do it cheaper or for free, but that's not going to happen in the near future.
And we're in the process right now of working with Workwell of putting together actually like a disability package where you come in, you can get the tilt table test, the CPET, neuropsych evaluation. So we're in the works and trying to figure out how we're going to pull that off during COVID, but that's the game plan right now.
Certainly exciting for me to hear for the first time. I'm glad. That's going to be great. Oh, man.
But I'm upset that people even have to go through all that stuff.
I agree.
Yeah, I mean,
you know, we know enough about the illness now that we shouldn't need to put people through those tests.
yeah, you know, if you never get through to Congress and ask them to change ERISA, then a lot of this will probably change. But I don't think it's very high on their list of priorities at the moment. I don't think they're going to get to any of their priorities anyway. Okay. So this is kind of a specific question, but what kind of criteria is necessary to see on a standing test to support impairment or disability? A certain amount increase in HR or heart rate or a change in blood pressure, question mark. I don't know the answer to this one. I hope you do, Dr. Dell.
Yeah, so there's a couple things. So stand test can tell you whether you have postural orthostatic tachycardia syndrome. And for an adult, that would be 30 beats above baseline heart rate, okay? But there's other things you look for. You look for a change in blood pressure. So that would be orthostatic intolerance, and that depending on whether you're looking at systolic or diastolic. There is change, like a 20-pound pressure change for systolic, a 10-pound change for diastolic. And we even look to see whether they call it narrowing of the pulse pressure, the difference between the diastolic and the systolic and the diastolic. So they're looking for a few things in there. And I'm trying to think if that interpretation is on the NASA lean test that I'll share with you. If not, I'll find it for you, because that's important to know. And your primary care provider may not know that information, so you might have to explain them. That's how you read the test.
Can you tell us more about the NASA lean test? I don't think we've had a chance to really talk about that today.
So that's the 10-minute stand test that we use. That's since, you know, it's about 87% sensitive for orthostatic intolerance or postural orthostatic tachycardia syndrome. Lucinda Bateman has this great little handout that she put together that shows how the test is done. And so I sent that to you, and that'll be part of the packet. And that's basically what we use in office to screen for orthostatic intolerance. I actually think it's much more accurate than a tilt table test. And it's becoming more accepted by cardiologists. So.
Are there a range of measurements which show a severity of impairment, or is it really more of a yes or no type of question?
Oh, there's definitely a range. And so you have to learn to look at it's a 10-minute stand test, and it's important to do it for 10 minutes, and it's important to do it every minute for 10 minutes, because you're looking at variations between 1 minute to the next throughout the 10 minutes. So there's a lot of information it can give. And so you have to sort of be familiar with how to read that test, but I'm going to see if I can find an interpretation, because then it'll be easy for someone to do.
Great. Okay, let's see if we have any other questions, any more live questions. Someone commented that Ithaca College, and that's where testing is done. The other place you can get 2-day CPET is Ithaca College with Dr. Keller, right? Dr. Betsy Keller? Yeah, I think that's right.
When I indicated the East Coast, I don't think Betsy's doing testing at the moment.
Right, yeah, I know she's not, but Betsy is the one who does it, right?
But yeah, that's okay. The other person that does it, yeah.
Yeah, so I think Ithaca overall, I think is shut down. So, okay. Let's see. What do I do if the SSA has stopped responding to my inquiries? It looks like this person, it's kind of a long question, but they're basically saying, they've sent in all their information and it's been like 5 months and she hasn't received a response. Is that normal, or what do you think this person should do? And you're muted still.
Okay, yeah, and I was reading that as well. We always tell people it's usually 3 to 6 months to get a response, so that's not abnormal. Unfortunately, you're dealing with that particular caseworker, and some are slower and some are faster. So, and it's notoriously difficult to get a hold of people at Social Security and get them to respond, so that's not uncommon. I don't think that it means that you're going to be approved or denied. It's really just a function of how much work that caseworker has on her desk, unfortunately. If you really want, you can try to speak to a supervisor. Not sure if that'll help. On the other hand, that caseworker does play a big role in the decision-making process, so you don't really want to antagonize that person. So.
We have thank you for that. We have a few more questions that have come in. Let's see. So can social media on which you only post photos of your small triumphs and pictures of yourself looking well be a problem for an SSDI or SSI case?
Yes, absolutely. Unfortunately, judges in particular are known to go to Facebook accounts. Or Instagram accounts. So, which is very frustrating because they might not tell you at the hearing and then they might deny you. So if they haven't even brought it up, you don't even have the chance to rebut it by saying, well, sure, I looked great, but then I was in bed for 3 days. So I'd be very cautious in what you put in your social media accounts. Very cautious. If you're going to post your triumphs, make it known that these were triumphs and that they were very difficult for you, and it's not something you do all the time.
If you treat your social media as if it's going to be seen by the disability carrier,
yeah,
maybe you can be safe, but I rarely see people actually posting their triumphs, and it feels like people put their best self out there on social media. They want to seem more active and more capable, and it can just help an insurance company kind of write a narrative about how bad your issues really aren't. and I'll never be able to prove this, but on many occasions, I've had insurance companies bring me social media, and my client swears up and down, it was all private. It was all private. There's no way I know, all of my friends, I don't accept friend requests, and I believe them. And I'm pretty convinced that the insurance companies use some, less than ethical methods to kind of access these things, whether or not, it's hacking or faking profiles to kind of sneak in as a friend, take all the info they need and then unfriend you, or even reaching out to your friends and asking if they would get your Facebook information for you for money. I've heard of that happening once, thankfully in my case, but yeah, social media is scary and dangerous, and I recommend treating it as such. So yeah, I didn't know the judges actually look, and the judges can look and then not disclose it to you before the hearing. That seems like everything wrong with.
Yeah, I mean, they sometimes will, and then at least you have an opportunity to respond. But we've had judges who won't bring it up in the hearing. I'm trying to remember, it's been quite a while, but I don't know how we found out that the judge did see something. I think perhaps it was in the decision or alluded to in the decision of something that the client had done and that the judge would only have known by looking at Facebook. But some judges will just say it during the hearing, have you ever gone golfing? Oh, no, no, I never go golfing. Oh, no, really? Because I saw on your Facebook post. Yeah, we actually have one judge who, she always asks, do you drink alcohol? And if the client says never, ever. So just be very careful how you answer those questions. Even if you only, do something once a year, once every 5 years, don't use those words. Don't say never. So.
Yeah, it just takes once.
Mm-hmm.
It just takes once. And, it's also a pretty significant generation gap between, the millennials and younger and, kind of the older generations. The millennials who grew up with social media, they kind of, it's social media. Of course, you're not being accurate about yourself. That's the whole point. And, the older generations are, well, why would you lie on social media? This is what you're doing, obviously. And so it's a huge disconnect. And so I find a lot of younger clients don't understand why we're so freaked out about what this much older judge is going to say about really benign Facebook stuff, but again, because it's all about credibility. And even judges, if they want to find a reason to rule against you because they have some, inherent bias, because everyone does, things like that can be like the window, to kind of step in. So it's something to definitely be mindful of. So, okay, another question. For Teresa Dowell about the disability package you were trying to set up, would the CPET be able to be done in Arizona or with the Workwell Foundation?
Well, we're hoping that we'll eventually have one in Arizona too. Mm-hmm. And so we'll have in Arizona, we'll have a clinic that where it will all be done in one place.
That's great.
Yeah.
I still have always liked the idea, Dr. Snell, of a mobile lab. We can, you can get to clients anywhere they are. You can get to them, and I know cost is a thing, but one day, especially with COVID, it's probably a lot safer than.
Appealing. That sounds really appealing to be just kind of driving around the country.
The equipment is quite temperamental, believe it or not, and it doesn't actually take kindly to being moved around. And we have looked very hard at portable equipment, and it tends not to be accurate enough for what we want. We always think that we're going to be questioned, so we don't like to leave anything to chance.
Yeah. Okay. Quick question. I've been told the wait for a Social Security hearing is 1 to 2 years. Is that right?
So before COVID, the wait we were telling people in California was generally actually longer than, it was about 18 to 22 months. So you could say 1 to 2 years. However, I have noticed with telephone hearings that we've been having, we are sometimes getting them more quickly. So if you are waiting, it could be quick, especially if you're able to and willing to waive notice of 75 days.
Got it. Okay. Is it possible to get the 2-day CPET done somewhere other than Workwell or Ithaca and then have the data interpreted by Workwell or Ithaca College? That's a good question. Dr. Snell? Leave this one. I would never begin to answer this before you.
I have looked at data from other places, and I am prepared to comment on it. Sometimes it's not done very well and is not particularly helpful. Sometimes it's okay, and I can say that it looks like the machine was reading accurately, and this data suggests that.
So no.
Yeah, I can do it, but it's, you've already paid for it. It's already done, and I might say I don't trust the data, and so therefore I can't comment on it, or the data might not show anything, and I'm going to say that it doesn't show anything, or the other option is that it is supportive of disability, and I would say yes, it supports disability.
Is it easy to just go out and find a lab to do 2-day CPET?
It's not that difficult to find a lab. It might be, what we've found is it's difficult to get people to do it well. So surprisingly, a lot of people don't calibrate their equipment because they're doing it for a sports science class where it doesn't really seem to matter to them that it's that accurate. The big thing is that people are not familiar with testing ME/CFS. And so if you've ever, Teresa's seen people do CPET, right, with ME/CFS, and it's a revelation. And so generally a normal sports science lab, which is usually it's going to be a sports science lab that does CPET, they don't do it anymore. They used to have them in hospitals for cardiac patients, but they tend not to do it anymore for cardiac patients. And so if you're not sensitive to the illness, you know, you can blow the test. If your equipment's not measuring correctly, then, you know, it's junk in, junk out. So it's not straightforward, but I'm not saying it can't be done. And I will look at a test and comment on it.
Is there anyone else besides yourself or Dr. Keller and Ithaca who could interpret a 2-day CPET that way if they couldn't, for some reason, were working with someone else or couldn't reach out to you?
I'm not going to say there isn't. I mean, it's not.
Nobody you know of, though.
I mean, I get people interpret them for insurance companies.
Well, yeah, I meant accurately and correctly.
And do a bad job of it.
That was implied.
But I mean, this is not a weird test. I mean, the only thing is we do 2 of them, but the single test that any competent exercise physiologist should be able to interpret a CPET test. Got it.
Well, and speaking of CPET, how much do you and Dr. Dowell know about the iCPET, the invasive CPET, if much at all?
Were you going to say something, Teresa?
Oh, I was just saying, all I know is that it's being done in research in the clinical setting, you know, a research setting. So it's not, as far as I know, it's not available to the public.
We had a patient send us one.
Yeah, it's available to the public. I've had a few clients who've had it done.
So I've seen one, and there was no more information in it than we get from a regular CPET.
Yeah, it apparently helped. I remember one client helped the iCPET, by the way, it's an invasive cardiopulmonary exercise test where, please correct me if I'm wrong, but instead of putting you on a bike 2 days in a row, they basically put a main line, a catheter in your artery and take measurements that way. So I couldn't recommend my clients do that because it's a very invasive medical procedure that I'd never want to risk with my clients. But some have done it for medical purposes and brought it to me. And so I was just curious how much you all knew about it. I've never seen a insurance company who knows what it is. You know, you need pretty much, you know, there's only a few doctors who could even explain it. And, you know, the insurance company physicians, you know, you're talking the top of the line physicians who are treating these people with this CPET, and the bottom of the barrel physicians who work for the insurance companies, you know, they don't treat patients and don't do anything else. You know, it's very hard to explain this upper level testing to these, you know,
Yeah.
sorry if there's any disability or insurance
But
peer review, low level doctors.
My point is that looking at the report, there was no more information there than we get. So the only thing you don't do the gas exchange, so which is the complicated bit. So I guess the reason that a physician is going to do it is that it's easier for them to do. But I don't see any advantage to it because I can't imagine it's cheaper. And it's certainly going to be a hardship to have a hard line put in.
Yeah, when I had it explained to me, I said, this is not something I'm ever going to tell my clients to do. This sounds very intense, but yeah, you know, more things going on. Okay, we have a few more questions before we wrap up. Kind of general questions. Oh, this one's interesting. So, what advice can we give someone if they are on disability and considering trying to go back to work part-time? Can it trigger a reassessment? Could it negatively affect them from a disability perspective? And they're also worried about, you know, hesitant to do anything that would worsen their condition. So in light of that as well, is it even worth trying? This person is apparently now able to do a few hours a week of useful work, not consistent, but sounds like she's really trying to do, you know, whatever she can. So from an SSDI perspective, how dangerous is it to return to work part-time below the SGA or the SG? You're muted. That's the signal, I think, for you're muted.
Okay, yeah, good question. If you're working part-time, it may or may not be enough to kick you off the benefits. It depends on how much you're earning per month. So for 2020, I believe it's about $1,280 a month. If you earn more than that, they have where for 9 months that you do that in a 5-year period, it's called the trial work period. So it doesn't affect you. However, once you go beyond those 9 months and you earn more than that amount per month, and it's actually lower to trigger this trial work, then the month after the 9th month where you earn more than that, then you can get kicked off the benefits. However, you can get back on them if you're unable to work again after that. In terms of just triggering a review, I haven't seen where it's necessarily triggering a review unless it's, you know, as I said, it's more than those 9 months where you're able to earn more than a certain amount. So, and just keep in mind, if you are earning more than $1,280 a month, which doesn't seem like a lot, after the 9th month, yeah, you will no longer be eligible. And, you know, the problem for a lot of my clients is that, you know, even if they're able to earn a little more than they would get with disability, they really need their medical insurance, their Medicare. So that's a real important thing to keep in mind. So the Medicare will not continue indefinitely if you are able to work.
So yeah, from an SSDI perspective, that's very important. But it doesn't sound like people have to be, if they work, let's say, make $600 a month. Does the Social Security Administration often then see that as a yellow flag that they might be able to return full time and then re-review them more frequently? Not really.
You know, it hasn't been in my experience because, you know, they have to show that you're able to engage in what they call substantial gainful activity on a continued basis. So I haven't seen that. We've had many cessation cases, and when you review a file of a case where they're trying to kick someone off the benefits, you do get a lot of that. You see what they're thinking. And I haven't had that happen. And, you know, it's funny, they usually are very good at documenting things that they really shouldn't be documenting. We've even seen them, it's awful, but it's also kind of funny. Sometimes they'll have their internal notes in there and they'll forget to take them out. And they'll ask a doctor who has reviewed the case, you know, the doctor, let's say, has said, yeah, I think this person is limited to this type of work, light work. Well, that would mean that particular person gets approved. So we've even had people write, the Social Security workers write back to the doctor saying, well, can you make an adjustment to that? So then the doctor comes back and says, okay, now the person is able to do medium work. So we have seen that. So I haven't seen, though, where they've discussed the amount of money that they're earning and then doing a review more quickly.
Wow, I thought that slimy stuff only happened with the private
It's
insurance.
awful. I don't think it happens very often, but it's something that was recently talked about amongst a bunch of Social Security attorneys, and it's pretty awful.
Yeah, you know, from a disability, from a private disability perspective, it's interesting because it can go one of two directions. If they find out you're working part-time or something and you haven't reported to them, they consider it a mark on their honor, and they will do everything they can to cut you off. They will review you every month. You know, they don't like being lied to. And their underwriters say if someone lies about a little thing, there's a very big chance they're lying about the big thing. So keep looking at this person. On the flip side, you know, if I see someone who's been on claim for a while and they're fighting to work 3 or 4 hours a week, you know, how does an insurance company say this person is faking it and sitting home and, you know, eating bonbons and watching TV when they could be working, when they're like scrapping to figure out a way to work 3 hours a week? Like it's so inconsistent with their narrative, what the narrative they would have to put forth to show that you are lying or that you are not disabled. Especially what's often even better for a disability claim is if you try to return to work for 4 or 5 hours a week and the employer says you can't do it. It's like, we tried to accommodate her, she can't handle 4 hours a week. Like it's just too much. And you know, it's not a lot of better evidence than an actual employer, you know, certifying you couldn't even work for a fraction of the time you need to work. Especially if your doctor is on board. It's very important to talk to your doctor and make sure they're on board, because you don't want to create any kind of clashes with your doctor. Because, you know, if they say they want you to do a treatment and you say no, sometimes they can use that and call you non-compliant. They don't really use that kind of stuff, but sometimes. But if the doctor's telling you, you know, yeah, I think it'd be great for you to try and work 3 or 4 hours a week, it definitely wouldn't hurt your condition. You know, it might even improve things. Give it a shot, and you go do it. It's great. I mean, that, you know, that narrative is very clean. If your doctor says, I think you should try and return to work part-time, and you don't, that might raise some red flags. If you say you really want to return to work part-time and your doctor says, no way, you can't do it, that's pretty supportive. So, you know, it depends on, you know, all the factors around it. But in general, if you're trying your hardest to work only a few hours a week, for the most part, they're at least smart enough to know that it doesn't look good for them to try and turn that into a denial. And if you're trying to work part-time, that's the first step to you returning to work full-time, and maybe they don't have to pay you anymore. So, you know, I think that's one of the reasons they also back off a little bit when you're trying to return to work and giving it a good faith effort. And that is kind of my experience. When you're trying to return to work, the private insurance companies really very rarely turn that into you know, them breathing down your neck if you've fully disclosed it and been honest, and everyone is on board. And you know, and if you have any, you know, and that just about actually concludes our time. One quick question: do I have any recommendations for trying to have health insurance reimburse or cover the 2-day CPET? Once it's supportive and you know it's supportive, you can ask for reimbursement. I still haven't figured out how to get it paid. So if you figure out a way to get it paid, email me. The LTD insurance company will never reimburse any money you spend in order to prove your case unless they explicitly tell you so ahead of time, which they will only do if they want you to consult a lawyer because they want you to sign something for them. So you won't get any reimbursement from them. It's a sunk cost, but it's certainly better than getting cut off.
We have had people claim some of the costs back, and they've been successful. Yeah.
Really?
Yeah.
Wow, that's impressive. Maybe I should start trying.
I'll check with Jared and see. We just provide them with information, and they make a claim against their insurance company.
Oh, the health insurance.
The health insurance. Yeah.
Okay, I was like, if you have disability insurance companies paying for this stuff, you got to tell me, because that's a major victory that I've not achieved yet.
Yeah, I don't know why they don't require people to do CPET, because it would catch them out.
Yeah. But anyway, so that don't want to hold anyone any longer than 7. Thank you all for coming and attending this. This has been really fun. To all our attendees, thank you for sitting and listening to us. If you have not had your questions answered, shoot us an email at benefitschat@cantorlaw.net, and I will do my absolute best, and so will the rest of the panel, to get back to you and answer your questions. We will send you a follow-up email with a link to the video, as well as some other some of the resources we were discussing, and our bios again, in case you want to read more about us. And we will let you know when we plan to do this again, which we plan to do again soon. So again, Dr. Dowell, Dr. Snell, and Moselle, thank you so much. Appreciate you all. Everyone out there, have a wonderful evening.
Thank you, guys. Stay well.
Bye-bye.